is Dustin Saldarriaga. I am an associate immigration attorney with Scott Legal PC in New York City, and we're going to be talking today about the E-2 visa, including its requirements, which is also relevant to renewing the visa. And we'll be doing that by focusing on the top and most common questions that we receive regarding the visa, particularly when we are preparing an E-2 visa application file. A few things before we get started. Some of you may know that our firm was actually founded on an E-2 visa by Ian Scott 10 years ago. Ian is currently in the US on an E-2 visa, so he knows exactly what any of you who are applying for the visa are going through. He has renewed the E-2 visa twice, and he can also share that experience with you all. Our firm is a full-service immigration firm. We do focus primarily on E-2 visas, and within that, we have a focus on assisting clients with what we would call riskier cases. Oftentimes what that means is that they have a lower investment amount, and we do have a very successful track record in assisting those clients with navigating the process. We have processed hundreds of E-2 visas, and we have processed them at consulates around the world. That being said, the primary two consulates that we do deal with are Toronto and London. We will be continuing this webinar series by presenting at least 2 webinars a month, and we present them on a variety of immigration topics. At the end of this webinar, we'll be sending you all a few things. First, we'll be sending you a PowerPoint that has all the information that'll be covered in this webinar. Just for your reference, we will not be using a PowerPoint presentation during our live presentation, but the presentation we send to you all afterward will cover all the information that we discuss in it. We'll also be sharing an E-2 visa guide, a comprehensive guide, and we'll share a link where you can sign up for the future webinars we'll be presenting. And finally, this webinar is being recorded. So at the end, in that email we sent to you all, we'll have a link where you can find the recording. You can also access this webinar and a variety of our past webinars, as well as shorter videos on a range of immigration topics on our YouTube channel. So if you go on YouTube and search for Scott Legal PC, you'll find our page, our channel on YouTube. And we really do try to put a lot of quality, high quality information on a variety of immigration topics for free on our YouTube channel. So do check that out. Finally, in that email, we'll have a link where you can set up a consultation. We tend not to get into the specifics of situations during webinars, but we're happy to discuss those during consultations afterward if you'd like to set those up, one of those up. We're very fortunate to have our founder, Ian Scott, with us today. He will be answering these frequent questions regarding the E-2 visa. Finally, if you all have any questions for Ian, please do share them. You can do so by either using the Q&A function on Zoom or the chat function on Zoom. I will be actively monitoring those, and I see that a number of questions are already coming in, so that's great. Please keep them rolling in. Without further ado, we will go ahead and dive in. All right, Ian?
Perfect. Excellent. Thank you very much, Dustin.
Perfect. So to start off, why don't we talk a bit about who can apply for an E-2 visa?
Excellent. So yeah, so again, thank you very much, Dustin. It's great to be here. And as Dustin mentioned, I'm on an E-2 visa myself, and 10 years ago was sitting in the shoes of of many of you. So I was actually able to apply for an E-2 visa because I hold a Canadian passport. So one of the kind of threshold issues with respect to an E-2 visa and who can apply for an E-2 visa is that you have to be a national of a treaty country. And what that means is there are approximately 80 countries that have signed treaties with the United States that allow nationals from those countries to come to the United States and obtain an E-2 visa. And I use the term national, and what that means is an individual who has a passport of the particular country, not someone who was born in that particular country, but someone who has an actual passport. And the interesting thing about me, and I use this to illustrate a point about who can and cannot apply, is that I also have a passport from the UK, which is also in a treaty country. However, the United Kingdom is the only place, the only country in the world where you actually have to reside in the United Kingdom in order to apply, have the passport and reside in the United Kingdom in order to apply for an E-2 visa. So if I wanted to, for example, apply for an E-2 visa based on my UK passport, I wouldn't have been able to do that unless I decided to go move back to the UK for a year or so and reside there over a period of time. But in terms of the country, you know, I mentioned a couple of countries that were on the list, Canada, the UK, but there are countries all over the world and you know, most continents. There are countries in Africa, Morocco and Egypt are both on the list. There are countries in Asia, many countries, Japan, for example, is on the list. South Korea is on the list. Then there are also countries, you know, many other countries. Pakistan is on the list. Bangladesh is on the list. You know, there are many countries in South America as well that are on the list, including Chile, Argentina. So you know, really the first step in terms of looking at an E-2 visa is that kind of threshold requirement of, do you have a passport from a treaty country?
Perfect. And Ian, you know, there are few very notable countries that are not on the list. So China, India, Brazil, South Africa. What is the typical, are individuals who are born in those countries simply barred from applying for an E-2 visa, or is there a possible pathway for them?
Yeah, it's a great question, and I think that what we're seeing more and more is that people, or you know, two of the countries that you mentioned, Dustin, China and India, the two most populous countries in the world, you know, individuals they're still interested in E-2 visa, and there is a mechanism to still get it, and that is to obtain citizenship or obtain a passport from a country that is an E-2 treaty country. So for example, a lot of our clients have decided to obtain citizenship in Grenada, and Grenada has a citizenship program where they'll issue you a passport for, I don't know the details, but let's say $250,000 investment in some hotel complex that you get a return over a period of time. And you know, you'd have to look at the specific details, but they'll issue you a passport relatively quickly. And then once you have that passport, you can utilize that passport to apply for an E-2 visa. And the you know, the one great thing about that particular country is, my understanding is that the passports are issued quite quickly. But there are other countries as well. I think Turkey has a citizenship program as well, and they're also an E-2 treaty country. But that is a mechanism for some people to obtain an E-2 visa.
Perfect. I'm curious to get your thoughts regarding why the E-2 visa really is such a popular visa, and specifically to frame it in terms of a question. What is the visa exactly? What does the E-2 visa allow? What are its key requirements, and kind of what kind of an applicant would want to consider an E-2 visa?
Absolutely. And I think that one of the reasons that an E-2 visa is such a popular visa is because it embodies what a lot of people think when they think of the United States, and the you know, kind of land of opportunity, and a land where entrepreneurs can really thrive. And the E-2 visa is set up, I think, for entrepreneurs, people who want to buy a business in the United States or start a business in the United States. And I think that, you know, when you look at the E-2 visa and you know, you look at the access to the E-2 visa and the requirements for the E-2 visa, you know, one of the key requirements for the E-2 visa is that you invest in the United States. Now, one good thing about that investment is that it doesn't, you know, there are other visas like EB-5 where you'd have to invest $800,000 or $1 million in the United States. But this particular visa, the E-2 visa, allows access with a much lower investment amount. So for example, when I started the law firm 10 years ago, the investment amount was very low, like, you know, under $50,000. And I think the amount that was actually spent was closer to $15,000 to $20,000. That's a very low investment amount. But you know, in terms of it's quite a stark contrast to 800,000 or $1 million. So, you know, the key though is that you're investing in the United States, and that you're actually, you know, what the government wants with this investment is that the funds are at what they consider at risk, so that you can't just invest in the United States and put money in a business bank account and say, you know, may I have my visa now? You have to put the money in a business bank account and then actually spend it on things, right? Spend it on the things that are required to get the business up and running. The other kind of key point to an E-2 visa is employees. And really, that is what this visa is all about. The investment is really a proxy for the examiner to be able to assess whether or not the individual is going to create US jobs. That's why the US government likes this visa. And that's, it's a key requirement of this visa. And that is that ultimately, so you don't have to have employees necessarily on day one, but ultimately you are going to hire US workers. And in terms of the requirements and the specifics of the regulations, the requirements don't indicate exactly how many US workers you're required to hire. However, we generally say to people that after a 5-year period, the government is probably going to look to see at least 3, the equivalent of 3 full-time workers at the company. And then, I'd say that the final requirement in terms of, there are some smaller requirements, but I'd say the final kind of larger requirement has to do with this particular visa is not a visa that is available for an individual who just intends to start a business. And this relates a little bit to what I talked about in terms of the investment. But the government is really looking for the business to be what's considered real and operating. So the business is either operational or right at the point of being operational. We had a individual who was applying for the E-2 visa. This was pre-pandemic. They were applying for an E-2 visa for a food truck, and the food trucks, interestingly enough, it's a whole business, and there are these companies that build out and design these food trucks, and it takes a while to do them. And he indicated that it would take probably 3 or 4 months for that food truck to be designed. And he said, well, if I just pay the amount now, can we just go ahead and apply now? And that was at a time when applications were being adjudicated very quickly. And we said, well, we probably should wait until the food truck is around 75% complete or complete before we apply. So the government is really looking at the business being real and operating, and so that even though, and this one is a hard one for people to swallow sometimes, because they actually have to spend the money before they get the visa, right? And it's kind of, we have a lot of clients ask us that, well, what if I don't get the visa and I've spent, $100,000? But I think that it's something with this particular visa, it is unfortunately something that you have to get your head around, because there is a requirement that the money has been spent and that the business is actually operational. So, it's set up that you have a bank account, you have a website up, you have, you've purchased everything that you require, you have a tax ID number, everything has been set up such that you are really able to walk in and start the business. I'll give one last anecdote to a client that we had that was setting up a gym in Arizona. And when she went to her interview, the examiner asked her, so if I went to the gym right now, what would I see? Right. And she said, well, we've leased the premises, the equipment's there, we've hired some staff, and really all they're waiting on is me to open the doors. And that's a perfect answer, right? In terms of what the government's expecting. Maybe not, you don't have to be right at the point of opening the doors, but if she said, well, her answer was, well, I've rented the space, but we still have to spend $40,000 on renovations, and the renovations might take 3 months and things like that. Then, the officer would have said, come back in 3 months once you've done that. So those are really the key requirements, and I think why people find this, some of the reasons why people find this visa quite appealing.
Perfect. Now, how long is the E-2 visa good for? And maybe you could also say a little bit about the difference between a visa validity period and having status in the US.
Yes, no, and this is a great question as well. What we, in terms of, so let's go to myself, for example, just to describe. So when I was issued my visa, I was issued the visa for 5 years, and it's renewable indefinitely, but there's a duration to how long the visa can be issued. But when you're looking at the validity period of an E-2 visa, the validity period is going to be governed by a few things. So one of the things that governs the validity period of an E-2 visa is which country are you from, right? So my passport is Canadian, so the maximum amount of time that my visa can be issued as a Canadian is 5 years. If you're from Australia, the maximum amount of time that the visa can be issued for is 4 years. If you're from Finland, the maximum amount of time, I believe, is it's either 1 or 2 years, but either 1 or 2 years. Now, there are countries like, for example, both Egypt and Morocco, the maximum amount of time that the visa can be issued for is 3 months. So let's talk about that a little bit, right? And I'll use this to kind of get into the difference between visa and status. So the visa, whether it's issued for 5 years, 1 year, 4 years, or 3 months, you should always think of a visa as an entry document only. So it's a document that says that you are permitted, or you're permitted to enter the United States, and you will use that visa and show that this visa, that it's been approved and that you have the ability to enter the United States. Now, when you enter the United States using an E-2 visa, then regulations take over in terms of that govern how long you can stay in the United States. So we ignore, because the visa, we're only looking at it, can you enter? Now, once you enter, then there are regulations that take over, and those regulations for an E-2 visa say that the maximum amount of time that you can stay in the United States is 2 years and do everything that you need to do for your E-2 visa: work, run your business, etc. Now, that's the same whether your visa has been issued for 3 months or your visa has been issued for 5 years. So let's take the example of an individual where the visa has been issued for 5 years. The individual, let's say on day one, they enter the United States, they enter and they've been admitted for 2 years, and that 2 years represents status. So that's no longer a visa. The regulations take over and say that your status is now E-2, and you can have a maximum status of E-2 for 2 years. Now, so what that means is that if you have a 5-year visa, that at the end of that 2-year period, provided you haven't left during that period, that you would have to leave the US at least for 1 day. Well, you leave the US, you can come back even the same day if you want, and revalidate your status, right? So, and you have to, and you have to really monitor your status in the US, because the visa, a 5-year visa doesn't mean you can stay in the visa for 5 years. But now let's take the example of someone who enters the US with a visa validity of 3 months. So that individual enters the US and they too have 2 years in E-2 status. But then what happens if they left the US after, could be during the 3 months, but let's say for purposes of clarity or ease, that they left the US 6 months later and wanted to return to their home country. Then in order to re-enter the US, they no longer have a valid visa. So they actually have to go back to the consulate and apply for renewal. So to get a new visa in their passport so that they can use that visa to re-enter the United States. And so then when they get a new visa and re-enter the United States, then they would be admitted again for 2 years and have a 2-year status. So but it's something to keep in mind, because I think that a lot of people default to, you might read on the internet or wherever that I have 5 years on an E-2 visa, or it's always going to be issued for 5 years, but that's not necessarily the case, and it is governed by country. The other thing that governs how long the actual visa will be issued for is the actual consulate, right? So a consular officer can decide that, so for example, you could go to the US consulate in, for example, London, and you could have you say you're starting a consulting business, maybe you spent a bit of money to get the business up and running, you don't have any employees yet, and then the consular officer thinks that, well, your case is okay, however, I'd really like you to prove that you're going to be able to hire US workers. So let's say that you're from the UK. So instead of issuing the visa for 5 years, because individuals from the UK can have the visa issued for 5 years, instead of issuing it for 5 years, the examiner decides that they're only going to issue it for 2 years. And then you're going to go back, because they're saying that, well, you can go to the US, you have 2 years, and then hire some employees, and then come back to us in 2 years and show us that you were able to hire employees, right? So that's that's what's going on there. So that's the other thing that kind of dictates how long the E-2 visa can be issued for. And there are many consulates that adopt that approach. There are some consulates that when the E-2 visa is approved, they will always approve the E-2 visa for the maximum validity period. But then there are many, many consulates that will really look at the application, and then if they feel that it's not as strong, that they issue the visa for a shorter period of time. And then when the person comes back to renew after they've had employees, they might issue it for the full duration.
Perfect. So we have some great questions rolling in, and a lot of them center on the requirements. So let's start with probably the most common question we receive, which is how much investment is needed for an E-2 visa?
Yes, and you're right. This is the key question. And one of the things I always try to encourage clients when they ask this question is to never think of this as just a number, right? Because I think that, clients are often looking for, well, what's the number? And often what they're looking for is what's the minimum number that I have to spend to get the E-2 visa. But I think there are a lot of factors that govern exactly how much you're required to spend when you have an E-2 visa. So the first factor really is what type of business are you planning on starting? So if you're planning on starting a business which requires a low investment amount to set up the business, then you could get away with a lower investment amount. I am going to come to numbers in a second, but I just want to describe the concept first. But if you're setting up a business that does require a high amount of money to set up the business, so let's say it's a restaurant. The restaurant requires expensive equipment. It requires you to buy furniture for the dining room. It requires you to pay a bunch of money to get the liquor license. All of these different things. Then you would have to spend more money in order to get that E-2 visa approved. So on the lower end, when people are setting up consulting businesses, what we, as kind of a combination or to add on to this question, is that even though we know that if you're setting up a consulting business that you could probably spend, I don't know, $5,000 and all you need is a laptop and a desk and things like that, that might be enough to set up that particular business. Unfortunately, there is kind of, even for those very, very low cost businesses, there is kind of a minimum threshold that a consulate's going to accept, even for those businesses that have a very low startup cost. Now, we've processed E-2 visas with client spending as low as $15,000 on these smaller consulting businesses or low entry cost consulting businesses. But we do recommend that clients spend at least $40,000 even for this type of business. And $40,000 often will not even work in some consulates. So something to consider. But then so the type of business is one factor that we're going to look at. Another factor that we're going to look at is where are you applying for the E-2 visa? Now, unfortunately, not all U.S. consulates are created equally, and some U.S. consulates don't look very favorably on E-2 visa applications where the applicant has not spent over $100,000 or even more. So there are consulates in the world that one of my colleagues joked, and when he heard how much we were approvals that we were getting in some consulates, and he mentioned this one particular consulate that they would laugh you out of the consulate with even $100,000 investment. They would laugh you out of the consulate. So you can imagine with a lower like 40,000, et cetera. So where you are applying, and that's where having a good E-2 visa lawyer is important, because the lawyer should take the time to make that kind of assessment. Sometimes the assessment is easier if it's a higher volume E-2 visa consulate. That assessment is easier. We can send something out to a number of our colleagues, or we have experience in that particular consulate. But then sometimes, unfortunately, when the consulate doesn't have a lot of E-2 visa applications, that assessment might be a bit more difficult. But where you're applying is definitely a big factor in the amount. And then the final thing to consider in terms of the investment amount is just how strong your case is. If you have a case that is very strong, if you have a case where you already have a number of U.S. workers, the business is already operational, it's already successful, then you could probably spend a lot less money. Or if you have a business, we did a business in Toronto, I think it was last year or the year before, where it was a doctor's office in essence, and she had a number of different contracts in place because the office was providing services for people that had a neurological disorder that wasn't curable. So the particular contracts that she had were very long dated with insurance companies. So she spent under $20,000, and we didn't for 1 minute think that that application wasn't going to be approved, because it was a doctor's office. The examiners can easily envision employees. Every time you go into a doctor's office, you see, people, usually employees working there. And also the contracts were very, very helpful to her case, in the sense of it was very, very clear that the business was going to be very successful, and it is. So, so the strength of your case is kind of the final factor, I would say, to look at to determine exactly what your investment amount should be. And then the final comment I'd say is that the lower the investment, the lower the amount to get the business up and running is the higher the percentage that you're required to spend. So anything under $200,000, you would be required to spend the full amount before. And I'd even say even a much higher number than that. But just to illustrate the point, if the startup cost for your business was $200,000, you should spend all of it, or invest all of it before you actually apply for the E-2 visa. If, for example, though, let's say that the startup cost for your business, let's say you were buying a hotel or developing a hotel, and let's say the startup costs were $10 million, then you could invest less than that, like, maybe 60, 70, 80%, or some amount that was less than that. And that could still be considered a substantial investment for the purposes of E-2. But for smaller investment amounts, it goes back to the intent to invest versus investing. For smaller investment amounts, if someone's buying something and they, it's $200,000-300,000, and you sometimes you have, well, can I just pay $200,000 now and $100,000 later, and things like that, and you wouldn't meet the substantial investment requirement if you hadn't invested the full amount.
Perfect. And we actually got I think it's a very, very insightful question. For someone who has a co-owner, so let's say we're doing two investors, each of whom owns 50%. How does the investment amount work there? Does each of them need to invest the minimum amount you've talked about, or can they split it in half? How does that work?
Sure. Yeah, it is an insightful and great question. I think that when you have two investors, the investment amount that if you're at the low end of the investment amount, right? So let's say that you have a service-oriented business and you have two investors, and each investor wants to, I used the amount before, that $40,000 is probably the lowest you want to start with. But if you had two investors, unfortunately, we wouldn't be able to then say that, well, okay, 20,000 each is enough, right? We would want to probably say 40,000 each, or maybe some number that was a little under 40,000 each. But definitely, if you have two investors and you're at the lower end of the investment range, then you want to increase the investment amount, right? Because when the new investor is taking up a position as well, because even when we're looking at employees, that person is going to be working at the company. And generally, an examiner is going to just want to see more if there are two investors. But as you start to get higher up the investment range, and there's no magic number, but as you start to get higher up the investment range, so let's say I take the example where two individuals are buying a restaurant. Let's say the restaurant costs $200,000, or they're starting a restaurant and it costs $200,000 to get that restaurant up and running, then 100,000 each would be sufficient. Like if you just split it, 100,000 each would be sufficient, in terms of you wouldn't, that would work with one investor and it would work with two investors. So you wouldn't have to then increase that $200,000 because there were two investors. So I think that as you get to, higher numbers, certainly over 100,000, then you can just kind of split the amount, and it's not really going to make any difference. But I just think it makes more of a difference once the numbers are a bit on the lower side.
Perfect. And we've received a couple of questions on the topic of using an escrow agreement. So I like how this question phrases it. Do I need to have actually spent the funds as outlined in the application, or can they sit in an escrow account?
Yeah, actually, it is an interesting question, and the reason I find this question particularly fascinating is because we had encountered some clients or prospective clients or people who had entered into or had heard about this arrangement where money could kind of go into escrow when it was just a business startup, and I never really fully understood what they were talking about or how that arrangement would ever work. So let me explain why I never understood it. Now, when we talk about escrow accounts, we talk and E2, we talk about escrow accounts in E2 in the context of purchasing a business, right? So you're purchasing a business and the seller wants the money, right? They want the 200,000. Let's say someone's selling a restaurant, the seller says, I want the 200,000. Now the regulations say that, well, you can't just, the buyer can't just keep the 200,000 and then apply for the E2. They have to give the money to the seller. But the regulations also permit transferring the money and putting it into what's an escrow account. And then the escrow, what escrow means, or the way escrow works is that there's an escrow agreement and there's a separate independent person or company that's holding the money, and what happens to that money is governed by what's in that agreement. So the agreement says that if the E2 visa is approved, and that can be the only condition, if the E2 visa is approved, the money goes to the seller. Right. And then if the E2 visa is denied, the money goes back to the buyer. And it's a carve out that the government has said that, because it is scary, right? If you're buying a business and you don't have the E2 yet. So the government has said this is kind of one exception. We're going to carve out where the money doesn't actually have to go to the seller, but the government is comfortable that the money is still at risk, because the only way that the buyer rather, can get the money back is if the E2 visa has not been approved. Now, let's contrast that to the situation where someone is doing a startup and the money is put into, I don't know, some escrow account, but it's unclear to me what the escrow agreement could ever say. There is no third party, right? There's no third party to do anything, right? So the escrow agreement has to, so the escrow agreement says if the E2 visa is approved, then what happens, right? But if if the E2 visa is approved, then the money goes back to the buyer, then the money's not at risk, right? Because it just is like, if they could just keep it in the bank in cash, it wouldn't be at risk. And if the E2 visa is denied, then it goes back to the buyer or the person who put the money in the escrow account. So it's never made a lot of sense to me. I think that in one instance, I did hear where the lawyer was holding the money, and then they would submit receipts, but it's not something that is very common, and not something that any consulate that is familiar with E2 visas would permit. So.
Perfect. And while we're on the topic of using an escrow agreement, and again, I think something you said is sometimes lost in our discussions, or a client's understanding of it, which is that an escrow agreement is not something you use typically for a startup where you're buying inventory and equipment. It is, you're buying one large asset, like a business. That makes sense for an escrow agreement. So this question is, can I buy a business from a family relative?
Yeah, so so you can. Yes, you can. You certainly can. However, the government can be suspect if you're buying it from a relative, right? So because the government could suspect that nothing is really going on. And we do warn clients with respect to related party transactions that the government could question them. So if you are going to buy a business from a relative, you should get an independent valuation done of the business, and even with it, and then you should pay that amount, right? And the valuation would have to make sense. But even with that, you may have an examiner that doesn't like it, right? And unfortunately, when you go to a consulate and apply for an E2 visa, there is no due process where they're denied and they have to provide an explanation and things like that. They'll deny your application, close the window, and say go, or we'll call security, right? So it's not there's no appeal process, nothing like that, right? So, and I just want to really illustrate the great answer to that question is, I'll give you a fact pattern from a client that we had. So this particular client was buying 50% of a gas station from her brother-in-law, and she obtained the money from her mother to buy the gas station, 50% of the gas station from her brother-in-law. She was applying at a very E2 friendly consulate. We warned her when she did the initial application that this could come up, this could be a problem, right? The consulate, the officer may conclude that nothing has really happened here. So she went to the consulate and she was approved, and she was actually approved for the full validity of her E-2 visa period. And she came back to the United States and then, operated her 50% of her gas station with her brother-in-law for 4 years. And then she went back to her home country to renew the E-2 visa. And she went and she got a different officer this time. And the officer said, I don't believe this application should ever have been approved. This is just money transferring between family. Your mother gave you the money. You gave the money to your brother-in-law, who's married to your sister, who is the child of your mother. So just thought it was money that was transferring around family, and that there was no real transaction that was occurring. So there was no investment that was made. And he denied the application. So the officer didn't renew the application. So I think it's good. It's illustrates. So the answer is yes, it can be done. However, it illustrates the, kind of the issues that you might face when you go to a consulate if they don't believe that it's actually a legitimate transaction.
Perfect. And, when talking about the investment amount, what the next E2 requirement that kind of logically follows from that, and you've already referred to this, is where the funds are coming from. So is it possible for the source of funds that are invested into the E2 business to be from a loan or a gift from someone?
Yeah, absolutely. That's no problem at all. Gift is no problem. It can be from anyone. It can be from a family member. It can be from a friend. It can be from an enemy. It can be It can be from anyone. The loan is also fine as long as the business is not the security. So all other loans, either unsecured loan is fine, or a loan where the security is your personal property. But the issue with loans, when the regulations are quite clear that you can't have a loan where the assets of the business or the business are the security. So that rules out any, for example, seller financing arrangements, right? You're buying a hotel and you pay $500,000 and then you have $500,000 seller financing, because the agreement is always, if you don't pay the $500,000, the collateral is the actual hotel. They'll take the hotel back. Similarly, if you're in kind of buying a house or any type of where you're, let's say you're doing a home renovation and flipping business or something like that, and you have multiple properties, and the properties have mortgages on them, then that wouldn't work. Or if let's say that you're buying a car as part of your investment and the car was financed, that wouldn't work, because the finance company, whenever they do that, they say that if you don't pay your loan, we're taking the car, right? And so that's the only type of loan that doesn't work.
And when the source of funds is a gift, can you say a little bit more about what documentation we would usually include in an application?
Sure, absolutely. So when the source of funds is a gift, we would want to include a gift letter, and then you should also be, that describes that this particular gift, they're getting the gift, and you'd also want to consider now with because processing times are quite can be longer these days than in the past. If it is a gift, you do the gift, or you want to consider that whether there was gift tax that resulted from that, because we see this sometimes in EB-5 applications, because they're so long dated that when it's a gift, when they come to adjudicate the application, the examiner asking, well, did they pay the gift tax? To assess whether it's a legitimate gift. And then as with a loan, whether it's a gift or a loan, because if it's a loan, you're going to have loan documentation, but whether it's a gift or a loan, then you're going to include documentation that shows where the person who gave the gift or the loan got the money from, right? Like now it's going to be easy if it's a bank loan and it's unsecured, that's going to be easy. It's a bank, you just say, I got it from the bank, and show documentation. But let's say that your mother or father gifted you, $200,000. Then you have to provide documentation that shows where your mother and father got that $200,000 from. And the nature of that documentation would just depend on where they actually got the money from.
Switching gears to another requirement that you mentioned before is really key, the marginality requirement. the question that came is, do I need to hire staff in the first 2 years? And maybe based on that question, if you could share more about what actually the hiring requirement is in terms of number of employees and over what period of time.
Perfect. Yeah, and it's you know, the government's, what's interesting about this particular statute and the E-2 statute and regulations is that the E-2 regulations don't ever mention the word employee. Instead, what they say is that the business cannot be marginal such that it only provides for the investor and his or her family. And that interpretation is that it means that the business, you have to hire employees, right? But it's the key thing with E-2 visas that you have to actually hire employees. Now, with respect to the question of do you have to hire in the first couple of years, the answer is no. However, because the regulations are clear that you have to create employment within a 5-year period. So the answer is no, you don't have to hire within a couple of years. But it's always a good idea if you're describing in a business plan that you will hire sooner rather than later, right? So I think that you know, if you entered a consulate and you indicated in the business plan that you didn't plan to hire anyone until year 3, I think that could raise red flags with respect to your ability to hire people. So I think that's I don't, although it's possible to do it, I don't think I'd recommend it. I would you know, recommend modifying the business plan to try and hire more people earlier. The other thing to keep in mind is that when you're applying, you know, I just described an application at the consulate. When you're applying through USCIS, an application where you didn't have hiring in the first 2 years would likely fail for slightly different reasons, because their USCIS has a very strict interpretation of what it is the owner is doing, the person who's developing and directing the operation, what they're doing. And if they have to do everything, like, you know, if they open a, you know, let's say they open a convenience store and they have to be cashier, they have to be stock person, they have to do everything, then they would describe that as unskilled labor and raise issues with that. So usually for USCIS filings, we have hiring immediately. You know, it doesn't you don't have to necessarily have someone hired when you submit the application, but the business plan would indicate that you plan to hire immediately. And then in terms of hiring over time, we like to, you know, if you have a, let's say you have a 5-year visa, we generally say that having the equivalent of 3 full-time employees by the time you go to reapply is a decent number to have your E-2 visa renewed without any issue. We can certainly and have certainly had E-2 visas renewed with less employees. But if you, after, let's say, for example, if you had 0 employees after 5 years, it would be very unlikely that you would have the E-2 visa renewed. And if you only had 1, I think that could be problematic as well.
There was a follow-up question regarding the marginality requirement, which is, the requirement states that the business's income should be enough to provide a minimum living for the investor and their family. How do we determine how much that is?
Yeah, I would say that I'm not sure that I don't recall that being a requirement actually, but I think that the way that the requirement is worded, it sounds like that's what the requirement is, but I don't believe that that's actually what it is. I believe that what the requirement says is that the business, a marginal business, is a business that provides only for the person and the investor and the family. I believe that's what the requirement, that's what the marginal business is not good, like it's not going to be approved. So that's slightly different from that the business has to provide for the family, right? So I think that what the examiner, but that's not to say that it's not a requirement. It's just not that wording doesn't make it a requirement. I think that when you know, if you have a business plan that shows that you are only going to make $20,000 a year in New York, then you would want to submit with the business plan a statement of net worth that shows that you would have sufficient funds to, you know, to live there, right? Because the government, what they're concerned with in E-2 is they don't really care whether you have enough money, as long as you have, like, you know, they don't want you to be a burden in terms of a public charge. But the idea is, what they're really concerned with is the is hiring U.S. workers, right? So so just to illustrate the point, if someone was a multimillionaire, and they were only making $20,000 a year, and they were living in New York City, but they could support themselves on that, the fact that they had other resources and they could continue, kind of paying for the employees that were there. That would not be a marginal business. So.
You mentioned the develop and direct requirement a few minutes ago when you were talking about USCIS and how they like to see an employee very early on. A question came in that is about the develop and direct requirement, but it's interesting the way it's framed. So the question is, there might be instances, I guess they've heard of instances in which an application is denied because the applicant, the E-2 investor applicant, does not need to be in the US and their employees can run the business. Is this actually a risk? And if it is, how would an applicant address that?
Well, I don't think that is a risk. So I don't think it needs to be addressed. I think that the investor, the E-2 investor, is always the question doesn't come up. A question of why does the E-2 investor have to be in the United States, right? So it starts with E-2 investor. Sometimes it comes up, why does the employee E-2 employee have to be in the United States, but not the investor? The investor, the reasons are obvious. It's their business. Right? It's if they own 50, at least to be an investor, you have to, 50% of the business. So a reasonable person is not going to, well, it's your business, you spent all the money, but don't come to the US and don't apply for an E-2 visa. So I don't think that that scenario occurs, or it's certainly not a question that has ever come up. The idea is that if you're an E-2 investor and you meet the requirement, you could apply, and the question of why is it that you want to go to the United States wouldn't come up. And keep in mind that because the answer could be as simple as, I want to manage my employees. It's my business, right? I paid the money, and that's a reasonable answer. So yeah.
And just to add a little bit to that, another question that comes up around this is there a minimum amount of time I need to spend in the US developing and directing the business? And I think people are surprised to learn that there's not. As long as you are entering the US to develop and direct the business, you're invalid E-2.
Exactly. It's a great point, because I think that the way I always think of it or describe it is that the E-2 visa gives you the ability to come to the US, and while you're in the US, you can work in the US, but it doesn't require that you do that. Right. So you could be a digital nomad for all they care. It's just when you are in the US, you do need a visa to work. And so, yeah, that's it.
Perfect. So we've spent some time on the E-2 visa requirements. I did want to shift gears because I'd say over half of the questions we've received are more on the procedural side, how
Sure.
you actually apply for this visa or the status. So, go ahead and switch perspectives a little bit on this. The first question I'll start with, can we apply for an E-2 inside the US, or should we apply only at the consulate? And a related question, can you renew the visa within the US?
Perfect. Yeah. So this question, it comes up especially since the pandemic, because so the answer is yes, you can apply for an E-2 visa while in the US if you entered on a B1, B2, or some other status other than ESTA. Right. So if you entered on the visa waiver program, there's no ability to change status in the US to E-2. But if you entered on some other, preferably you entered on B1, but even if you entered on B2, it's going to be possible. Or if you're in the US on an F1 or some other H1B or other visa, you could change status in the US. And what that involves is filing a I-129 petition. And the requirements are the same, but the application of those requirements or the adjudication is different, right? So when you're doing a USCIS filing, they're going to focus on, for example, the employee thing that we mentioned earlier, employees like, on day one. Also, they focus a lot more on the source of funds. When I went through the initial requirements, I kind of intentionally didn't go over source of funds, because for a consulate, we kind of gloss over source of funds. We provide general evidence that the funds came from a legitimate source, but USCIS, that is quite an in-depth part of the application for a change of status. Now, when you do a change of status, It is not a visa. So all it is doing is changing your, for example, your B1, it's changing it to E2, and that's going to be valid for a 2-year period. But it's not a visa. And remember what I said about a visa, that a visa is an entry document. So if you left the United States, that change of status is null and void. You can't take that approval notice and take it to a consulate and get a visa stamp or anything like that. So that's why in the past, a lot of people haven't been that fond of doing a change of status, because it's a lot more documentation. There's no page limit for USCIS, in-depth source of funds analysis. They're much pickier with respect to many aspects of the application. And you know, when you leave the US, it's as if nothing happened, right? A consulate doesn't care that you have the approval in the US, and you are going to ultimately, if you do want to do any traveling at all, you would ultimately have to get the application processed at a consulate. So before COVID, I would say 99.9% of our applications were done at U.S. consulates abroad, and there were very few exceptions, right? So you know, there were people who had good reasons for applying in the U.S. You know, either they were lived from a country where the consulate was very difficult on E2s, or other reasons why. But generally speaking, overwhelmingly majority of the applications were done at a consulate. But then COVID came along, and consulates closed, and even now many consulates, some are closed, and other consulates, even popular consulates like Toronto, if you submitted an application today, you would be scheduling an appointment about a year from now. So it's business, right? People needed to start their businesses. So sometimes they were in the United States. So we filed an enormous amount of change of status applications because the people had to start their business, right? So it's in many cases, we would file the change of status application, but then also simultaneously file the consular filing application, so that when they did get their interview, they could actually go to the consulate. But generally speaking, the consulate, you know, it does have the advantage of giving you the visa, and in particular for countries where the visa validity is long, like 5 years. Like there's not so much benefit for countries that have 3-month visa validity, but the ones who have long visa validity, that's often why we push for the push for people to go to the consulate.
And a few questions have come in about the form I-129. So the form I-129 is the form that is filed to change or extend your status in E2 or in E2 status. Now, one question was, if you're filing the form I-129, would it be the individual filing that, or would it be the company that's filing that?
Yeah, so the petitioner is always going to be the company for an E2. So there's no, so the way that the form is a bit confusing. It says the beneficiary is going to be the individual who is applying for the E2, and the petitioner is always going to be the company. So so what's interesting about this particular filing is that even if the filing is denied, it's not a denial for the individual, it's a denial for the company. And so that's important when you're doing, you know, applications in the future. You don't have to tick a box that I was denied a particular visa. You know, so you still have to monitor. Filing it doesn't keep you in status, right? Filing it, if it's denied later, then and you've gone past your I-94 date, you still be out of status. But it is the petitioner company that is filing.
Great. Now, I like this question that came in about E2 dependents, because it gives us an opportunity to say that there are a number of benefits that are available if you are the spouse of an E2 visa holder. You can now work automatically once you enter the US as an E2 dependent. Spouse and children can attend school. Now, this question is interesting. If someone is applying for a change of status to presumably the E2 principal, E2 investor within the US, but their spouse, the E2 dependent, is going to consular processing, can they apply together, or does the spouse need to wait for the E2 approval? And actually, I think in understanding the question, since they're suggesting they would apply together, presumably they're both doing consular processing. But I'm curious if you have thoughts on the best procedure if there is an E2 dependent, whether they always need to apply together or whether the dependent can follow and apply for the visa later.
Yeah, so I think that, and I'm just reading the question here as well. Will apply for change of status while my wife E2 dependent will go for. Okay, so I think that it depends on. I think it depends on the person's preference and what their travel plans are and what it is that they want to do. So I'm assuming for the question that the E2 visa is approvable, right? So I would think of it as that if the E2 visa is approvable, then the spouse is going to be eligible for an E2 visa or E2 status, whichever, whether they're in the United States or whether they're at a US consulate abroad. Now, I think that the determining factor, though, might be that if both parties are in the United States and the I-129 is filed for the primary applicant, if you have dependents, you file a different form, which is an I-539. Now, the issue with the I-539 is that the I-539 cannot be premium processed. So the spouse might have to wait a year or so before they get their work authorization. So whereas if both parties just went to the consulate and got their E2 visas and then re-entered, the spouse would automatically have work authorization without having to file anything. One kind of very recent change is where the Foreign Affairs Manual was updated to reflect this, was that if an individual, like let's say the primary applicant files for an E2 change of status in the US and gets that approved, the dependents now can use that approval notice to get the visa at the consulate. So that's something that's relatively new change, because it was something that didn't really exist before. So I think the timing just really depends on what the individual wants to do.
Great. And I like another question that rolled in, which in summary is asking whether the government re-adjudicates the E2 petition at the border. So the specific question is, if you get a visa from your home country, and let's say, I think they were referring to your example with a past client who was approved at the consulate with a very low, or maybe a family-based business purchase. When they're entering the US, even if they had a risky application at the consulate, is there a chance that the border officer, the official at the airport, is going to look at the application again and possibly question them about that again?
It's unlikely. It's very, very unlikely. The time that the time I'd say that you hear about, there are very few instances where we actually hear that a border official asks anything of an E2 visa holder other than, what type of business are you doing and things like. I've entered probably 100 times and have never really been asked anything other than what's the name of your business or what type of business is it. And I think that our clients, their experience has been the same. So I think is it possible? Absolutely. Anything's possible. They can call you into a room, go through your phone, laptop, anything that anything's possible, but I think it's unlikely.
Great. And Ian, I'm looking at the clock. I know we only have 3 minutes left. My thought in terms of the remaining 3 minutes, because we actually have gone through the questions we've received. So if any of you who are attending have other questions, feel free to send them in. In the meantime, I thought it would be good to ask you about when someone has been on an E2 visa and the business has changed. Let's say that the business has expanded and maybe is focused on an area that's outside of what the business plan specified. Or let's say that the owner has sold part of their equity.
Mm-hmm.
What happens when there's a change to the business?
Yeah, so definitely the regulations indicate that if the change is a substantial change or substantive change, then you have to file an amendment with USCIS before you actually change, right? So you'd fill out an I-129 form and file that amendment. Another way of doing it would be just going back to the consulate and reapplying for a new E2 visa as well. But definitely, we try to limit what we consider substantive change. So, someone is doing a restaurant business and they didn't indicate that they were going to be doing catering or they were going to be doing something else. If any way we can relate it to the restaurant business, we would consider, or if it was a small part of the restaurant business, we would not consider that substantial. But let's say someone starts a consulting business under E2, but then, later decides that they want to you know, flip homes doing real estate and then stops the consulting business and starts a real estate business, that would not, you know, that would be considered a substantive change, and you would have to, you know, file an amendment and show, basically provide the government with documentation that you, you know, that you were able to meet all of the E-2 visa requirements.
Great. And I know one question did come in while we were discussing that last question. And in summary, this question, I think, is asking for our assessment of the odds of denial, which we of course can't give. But I do think we can respond to one aspect of the question, which is going back to the investment amount. If someone has committed $60,000 into a business, but 45,000 of that is working capital, 15,000 has actually been spent. Would that be considered a risky E-2 application?
So yeah, so I'd say yes. I'd say that, you know, when we, even, you know, in our engagement letter, when we send it out and we say, like, you know, we say to people that the minimum you should spend is $40,000. So we don't say put in a bank account, we say spend. And then but we also go further and say that even that is a risky case, like 40,000, because it is the government considers it a low amount. So yeah.
Great. Well, Ian, thank you so much for taking the time, and everyone, thank you for attending this webinar. Please do keep a lookout for the webinar we'll be sending to you all. And in the meantime, if you have questions about your specific situation, do not hesitate to schedule a consultation. We're always happy to talk. So Ian, thank you.
Thank you.
Have a great day.
Actually, thank you, Dustin. Thank you, everyone. Take care. Bye-bye.